Hello all, this is Mrinal Dattatreya Bua, advocate practicing before Supreme Court of India and visiting faculty for the cyber laws at ILI. Today we are going to discuss a topic, surveillance in cyberspace. Learning objectives for the today's discussion are meaning of online surveillance, governing laws of online surveillance in India, governmental departments involved in online surveillance, the relationship between online censorship and online surveillance, criminalization versus decriminalization of online speech, the status of UID project and the relevant privacy concerns related to the project with reference to the online surveillance, India and the globe, an analysis of role of ISPS and TSPS in the online surveillance. These were some learning objectives. Now we will be looking into a little introduction for today's discussion. Internet is nothing but a social contract. Netizens have automatically become a part of social contract. Once they start use of an internet and submit their information to the online world, which creates some issues such as online surveillance, online censorship and privacy protections. International state-sponsored cyber espionage has given a birth to twin narratives of cyber war and cyber arms race. Narratives which are being used in some parts of the world to encourage citizens to trade in civil liberties for a greater sense of security. Internal threats to national security occurred. The use of new technologies have long been used to rationalize widespread surveillance measures. Illustratively, in India, it is not allowed to access mobile phones, public Wi-Fi or internet connections, including cyber cafes, without authorized proof of identity and verification. And both ISPS and cyber cafes have to retain exhaustive logs of users' browsing history. The histories of portion that regularly accompany such methods draw advance power from the right existence advancement of cybercrime. While cybersecurity is not a new worry, in the last few years it has come to progressively control and drive the internet policy and governance agenda as well as international policy treaties. Genuine threats do certainly exist. Unlawful access to computer and data as well as data interference have become more common and complex problems that affect large number of people and government. Questions like deception are captivating a new arrangement on the internet. Furthermore, as India's critical information structure becomes dependent on the internet, security breaches can have important consequences. Counting for human rights when, for example, an attack averts people from accessing public services or exercising their right to expression. Where government's identity security threats, these should therefore not be made light of priority. It is a vital duty of any state to ensure that security of people within its boundaries, and this duty does extend to the cyber domain. The use of emerging technology in the implementation of surveillance practices has resulted in new issues and concerns arising for the protection of an individual's right to privacy. In India, such practices and technologies include the UID project and privacy issue of Aadhaar card holders, iCards, human DNA profiling, the collection and use of biometric, video surveillance and telephone interception are creating issues relating to the privacy, autonomy, bodily integrity, dignity, equity and personal liberty of an individual. Hence, it is relevant to discuss the role of online surveillance in governing virtual space in general and with special reference to India, finding best practices and solutions to the present issues which have arisen out of online surveillance. Now, we are moving to the first chapter, that is concept of online surveillance with reference to India. Firstly, we will be having look over the meaning of surveillance. Surveillance is the close observation of person or groups, especially the one who are under suspicious or the act or observing or the condition of being observed. The object of the Information Technology Act 2000 is to provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic methods of communication and storage of information, to facilitate electronic filing of documents with government agencies, and further to amend Indian Penal Code, the 1860, Indian Evidence Act 1872 and the Bankers Book Evidence Act 1891, and so also the Reserve Bank of India Act 1934 as well, and for matters connected therewith or incidental thereto. However, with the passage of time, as technology developed further and new methods of committing crime using internet and computers surfaced, the need was felt to amend the IT Act 2000 to insert new kinds of cyber offences and plug in other loopholes that posed hurdles in the effective enforcement of the IT Act 2000. This led to passage of the Information Technology Act 2008, which was made effective from 27th October 2009. The IT Amendment Act 2008 has brought marked changes in the IT Act 2000 on several counts. With the growth of the IT sector in India, the use of monitoring and interception of telephone and digital communications has also risen. The growth in the use of these technologies and practices raises the question whether or not present Indian legal provisions addressing surveillance have adequate safeguards in place, and whether the privacy of Indian citizen is secured against the unlawful or illegitimate intrusion by the state. Being a developing state, India has introduced numerous modifications into its policies on information technology, and yet more modifications which are required to be done, and the reasons for such issues are there. So, we will be looking into those reasons for those issues. First reason is Section 66A was introduced by the Information Technology Act 2008 to punish persons for sending offensive messages, which is declared as constitutionally invalid, patently in the violation of Article 19(1)(a) of the Indian Constitution. The first part of the provision was provided for the fact if some information is grossly offensive as provided under Section 66A Clause A, or that causes annoyance or inconvenience while being known to be false as provided under Section 66A Clause C, cannot be a reason for curbing the freedom of speech unless it is directly related to decency or morality or public order or defamation or any of the four grounds listed in Article 19 Clause 2. The later part of Section 66A Clause C talked of deception was to combat spam and phishing. This issue has been resolved and clarified by the judgment of Apex Court, which has been discussed in detail in the later part of this discussion with criminalization versus decriminalization of online speech. The next reason is Section 69A grants power to the central government to issue directions for the blocking of public access to any information through any computer resource, while necessity or expediency in the terms of certain restricted interests are specified. Sufficient guidelines have not been specified. Those guidelines as per Section 69A Clause 2 shall be such as may be prescribed. It has to be ensured that they are prescribed first before any powers of censorship are granted to anybody. The third reason is it must be ensured that until the procedures and safeguards mentioned in subsection 69(2) and 69(b)(2) are drafted before the powers granted by those sections are exercised. Small scale and targeted monitoring of metadata is much more suitable solution that will actually lead to results. Instead of getting information overload through unchanneled monitoring of large quantities of data. If such safeguards aren't in place, then the powers might be suspect constitutionality because of lack of guided exercise of those powers. Now the fourth reason is the amendment to the provision on intermediary liability, that is, which is provided under Section 79 of Information Technology Act 2000, While it is a change in the positive direction, as it seeks to make only the actual violators of the law liable for the offences committed. Still, it isn't wide enough. This exemption is required to be widely worded to encourage innovation and to allow for corporate and public initiatives for sharing of content, including via peer-to-peer technologies. The reasons which we have discussed, the issues which were arisen, and the modifications which are required to be done will be discussed in the later part of the discussion. India does not have dedicated legislation governing online surveillance in India. This has resulted in an unharmonized legal regime. The provisions addressing cyber surveillance found in various legislations. Firstly, the first legislation is Information Technology Amendment Act 2008. Section 69A of the Information Technology Amendment Act 2008 provides the authority for authorized governmental security agencies to intercept, monitor or decrypt any data or information stored on any computer resources for the reason of public safety, public order, etc. But who shall be authorized to intercept this information is unknown. Amended IT Act totally redrafted its provisions in the connection to legal interception. The present section 69 deals with the power to issue directions for the interception or monitoring or decryption of any information through any computer resource is much more explanatory than the one it changed. Then the next legislation is Information Technology Procedure and Safeguard for Interception, Monitoring and Decryption of Information Rules 2009. On October 27, 2009, the central government notified the Information Technology Procedure and Safeguard for Interception, Monitoring and Decryption of Information Rules 2007 under Section 69 of the IT Act. The rule provides that no person shall intercept, monitor or decrypt any information available on any computer resource apart from an order from Home Secretary or Joint Secretary, Ministry of Home Affairs has been acquired to do so. According to the Rule 4, the central government has power to delegate such authority to intercept, monitor or decrypt any information on any computer resource to any agency. Then the next legislation is the Indian Telegraph Act 1885. The Indian Telegraph Act 1885 has also specified an authority to central or state government to intercept any communication if it is against public safety, and since then, as various laws came into force, the government has got power. The first safeguards are from the case of PUCL versus Union of India. In this case, Honorable Supreme Court of India held that the interception of communication was violation of the constitutionally guaranteed right to life and personal liberty unless permitted under the procedure established by law. As a part of judgment, Supreme Court framed guidelines to be followed when intercepting telephone lines. The central government noticed the Supreme Court's procedural safeguards as rules under the Telegraph Act. The rules state that only a Home Secretary from the central or state government can authorize a wiretap request for interception must specify how the information will be used. Each order, unless cancelled earlier, will be valid for 60 days and can be extended to maximum of 80 days. A review committee at the central or state level will validate the legality of interception order. Before an interception order can be approved, all the possibilities of acquiring the information must be considered. The review committee can revoke orders and destroy the data intercepted as well. Records pertaining to an interception order maintained by intelligence agencies will be destroyed every 6 months unless required for functional purpose, and records pertaining to an interception maintained by the state provider will be destroyed every 2 months. In case of an emergency, immediate interception can be authorized by the Joint Secretary or any official above, provided that the Union Home Secretary is informed within 3 days and receives confirmation. The Honorable Court further observed that Section 5(2) of the Act clearly provides that occurrence of any public emergency or interest of public safety is sine qua non for the application of these provisions. Neither of these are selective conditions or situations. Either of the situations would be apparent to be a reasonable person. In this regard, the Honorable Court observed in the case of Hukumchand Shamlal versus Union of India and others, stating that economic emergency is not one of those matters expressly mentioned in the statute, and further that mere economic emergency may not necessarily amount to a public emergency and justify action under Section 5(2) of the Act, unless it raises problems relating to the matters indicated in section. Public emergency would mean the prevailing of sudden condition or state affairs affecting the people at large, calling for immediate action. It is one which raises problems concerning the interest of public safety, the sovereignty and integrity of India, the security of the state, friendly relations with the sovereign states, or public order, or the prevention of incitement to the commission of an offence. Public safety means the state of condition of freedom from danger or risk for the people at large. It has been stated further that when either of these two conditions are not in existence, authorities cannot resort to telephone tapping, even though this satisfaction that it is necessary or expedient to do so in the interest of sovereignty or integrity of India, security of state, friendly relations with sovereign state, public order, or for preventing incitement to the commission of an offence. But there is no such legal mechanism passed by the legislature in connection to surveillance and establishment who has an authority to monitor and block information for any computer resource. However, by whom this power is given or when such surveillance will be done is an issue. The next legislation is Right to Privacy Bill 2011. The Right to Privacy Bill 2011 has been presented in the Parliament, and an effort has been made by government as to describe privacy under which situation the government has control to conduct surveillance, and what shall be punishment as to misuse of such information acquired by the way of surveillance. Under this bill, surveillance can only be granted by permission of the Home Secretary, Ministry of Home Affairs and Government of India, which is not different from the present scenario. The next legislation is Information and Technology Procedures and Safeguards for Blocking of Access of Information Public Rules 2009. These were notified under Section 69 of the IT Act by the Indian legislature in order to block access of any information or any computer resource by public. As per the rules, the government has an authority to block information if caused, communicated, saved or received or accommodated by any computer resource for any purpose stated in 69A of the Information Technology Act 2000, such as sovereignty and integrity of India, defense of India, friendly relations with foreign state, security of state. In addition to Section 69, government has been authorized under presently introduced 69B to monitor and collect traffic data or information generated, transmitted, received or stored in any computer. Traffic data has been defined in section to mean any data identifying or purporting to identify any person, computer system or computer network or any location to or from which communication may be transmitted. Rules have been given out by the central government under this section. That is the Monitoring and Collecting Traffic Data Rules 2009, which are alike while with significant differences to the rules issued under Section 69. Therefore, there are two simultaneous interception on observing government in a place under the IT Act. In the paragraphs that follow, summary of surveillance by government under Section 9, meanwhile, they are more belligerent in the direction of the individual and therefore the intimidation to privacy are graver, while emphasizing significant changes in the rules drafted under section 69B. Then the next point is departments working under Indian governments for surveillance. This chapter highlights a way in which the India government can conduct surveillance and access individuals' online data. Such actions are hazard to freedom of expression. As soon as people recognize or consider that governments or companies are observing their private communications, they are less motivated and less likely to communicate easily. The United Nations Special Rapporteur on Freedom of Expression, Frank Le Roux, submitted a report on the Human Rights Council drawing how government and business surveillance has weakened freedom of expression and privacy. This report provides that privacy and freedom of expression are interrelated and equally dependent. A violation upon each other as to reason and result breach. Surveillance abilities possibly break international human rights principles and have been conditioned to judicial challenges. In 1996, the Supreme Court held that the citizen's privacy has to be protected from abuse by the authorities. Yet, Section 69 of the IT Act provides the state surveillance powers in circumstances that interception can take place from emails, chat, etc. in the interest of the sovereignty and integrity of India, the security of state, the friendly relations and foreign state or public order, or for preventing incitement to the commission of any cognizable offence relating to above. In 2011, Parliament enacted a data security rules, but there is no privacy legislation in India. Privacy is a basic human right and reinforces human dignity and added important principles such as freedom of association and freedom of expression. Major modifications proposed by internet activists inculcate a privacy bill to deal with the issue of data security and surveillance, and the formation of a privacy commission, the report of which suggested 5 salient features of such framework such as technological neutrality and interportability with international standards, multidimensional privacy, horizontal applicability, conformity with privacy principles, and co-regulatory enforcement regime. Further rules notified under Section IT Act pertaining to cyber cafe included provisions that can enable physical and online surveillance of cyber cafe users. Moreover, Indians are legally required to register their actual names to activate SIM cards and mobile and internet services providers, that is ISPs, are needed to allow government organizations access to consumer data. If the courts allow the supply of requested user data, there is a possibility that it can violate free speech online. If the data is admitted as an evidence for trial, at the end of 2012, key telecom companies in India were required by the government to install technology that would allow for the interception of communications sent via BlackBerry. The government has reliably entreated the foremost web business corporating established servers in India to grant them observe local communications. The Google Transparency Report displays that India comes second following the United States in the case of government request for users' data. A similar type of report was released by Facebook in August 2003. In absence of a privacy law and safeguards to protect data, the collection and preservation of such data can be distorted and can produce alarming consequences among the Indian population. Now we are moving towards the next chapter, that is lawful interception and monitoring of electronic communications under the IT Act. In continuance of harm of privacy by criminal and with roguish internet, electronic communications and storage are also goldmine for governmental supervision and surveillance. This chapter provides a great general idea of provisions in the Information Technology Act that confine the authority of the state to intercept the electronic communications, from which the first point is what is unlawful intercept. In August 2007, Lakshmanna Kailash K, a engineer from Bangalore, was apprehended on the doubt of having posted offensive pictures of Chhatrapati Shivaji, a key milestone historic king, in the state of Maharashtra on the social networking site that is Orkut. The police recognized him based on IP address details gained from Google and Airtel. Lakshmanna's ISP was gained from these Google and Airtel. He was brought to Pune and arrested for 50 days before it was arrested for the concerned action. 50 days before it was discovered that the IP address was provided by Airtel was wrong. The error was manifested. It was because asking the information from Airtel, the police had not properly stated if the suspect had posted the content at 1:15 PM or AM. Taking cognizance of his plight from newspaper accounts, the State Human Rights Commission consequently ordered the company to pay rupees 2 lakh to Lakshmanna as damages. The event highlights minor privacy infringement by ISPs and intermediaries could have effects that seriously weaken other basic human rights. The next important point for the discussion is authority to intercept. Section 69 authorizes the central or state government or any of its officers particularly approved by central or the state government, as the case may be, to exercise powers of interception under this section. Under the Interception Rules 2009, the Secretary in the Ministry of Home Affairs has been designated as the competent authority with respect to the central government to issue directions pertaining to interception, observation and decoding. Likewise, the individual state secretaries in charge of home departments of various states and union territories have designated as competent authorities to issue directions with respect to state government. Now, kindly have a look over table 1, which describes the authority to intercept. However, an exception is made in cases of emergency either. The first point is A. In remote areas where obtaining prior directions from the competent authority is not feasible, or for operational reasons where obtaining prior directions is not feasible. In such cases, it would be allowable to transmit or interception after procurement of the orders of the head or second senior most officers of security and legal execution at the central level, and an approved officer not below the rank of Inspector General of Police at the state or union territory level. The order must be conveyed to the capable authority during the period of 3 days after its issuance, and sanction must be received from the authority during the period of 7 official working days. In absence of the same, the order will become infructuous. Where a state or union territory requests to intercept or monitor or decode the information outside its territory, the competent authority for that state needs to do a request to the competent authority of the central government to pass suitable orders. Now we are shifting to next point for the discussion, that is circumstances under which may directions be issued to intercept. Purposes for which interception may be ordered under section 69. The authority of interception may be worked out by the approved officers when they are pleased to do essentially in the interest of sovereignty or integrity of India, defense of India, security of the state, friendly relations with the foreign state, or public order, or preventing incitement to the commission of any cognizable offence relating to above, or for investigation of any offences. Under section 69B, the competent authority may issue guidelines for observance for a choice of cyber security purposes, stating that recognizing or chasing of any individual who has broken or is alleged of having broken or being likely to breach cyber security. Now have a look over the next point of discussion, that is contents of order. The explanation for the directing monitoring must be recorded in writing. As far as the order under section 69 is concerned, in reaching the findings, competent authority must deliberate if there are other ways of obtaining the information prior to issuing an order for interception. The order must be limited to the content that is sent or possibly to be sent from one or more exact computer resources. The order must contain the name and details of the officers to whom acquired information to be revealed, and also stipulate the use of the information. Now, The next point is duration of interception and periodic review. After an issuance of interception order, such order will be in force for a period of 60 days in absence of previous withdrawal and may be reintroduced for an entire period not more than 180 days. An order issued under section 69B does not lapse mechanically because of delay of time and ideally would remain in force until withdrawn. During the 7 days of its issuance, a duplicate of an order passed under section 69 or section 69B must be dispatched to the review committee created to superintend monitoring under the Indian Telegraph Act. Every 2 months, the review committee has to meet necessarily to take a note of its conclusions as to if the order was validly issued in as per section 69(3). If the review committee is of the view that the order was not valid, then it can set aside the directions and order of elimination of entire collected information. The next point is authority of interception. The competent authority may, in his written direction, direct agency of the appropriate government to intercept, monitor or decrypt or cause to be encrypted or monitor or decrypted any information generated, transmitted, received or stored in any computer resource. Accordingly, the subscriber or intermediary or any person who is in charge of the computer resource must, if required by the designated government agency, extend all facilities, equipment and technical assistance to firstly to provide access to secure access to computer resource generating, transmitting, receiving or storing such information, or to intercept, monitor or to decrypt the information as the case may be, or to provide information stored in computer resource. The intermediary must maintain records mentioning the intercepted information, the particulars of the person, email, account, computer resource, etc. that was intercepted, the particulars of the authority to whom the information was disclosed, number of copies of the information that were made, the date of the destruction, etc. This list of requisitions received must be forwarded to the governmental agency once every 15 days to ensure their authenticity. In furtherance, accountability is rest with the intermediary to keep in place sufficient internal checks to ensure that unauthorized interception does not take place and extreme secrecy of intercepted information is required. Now, the next point for the discussion is how long can information collected during interception be retained? The interception rule requires that all records, including electronic records that are part of an interception order, to be destroyed by the government organization in every 6 months, apart from a case where such information is obligatory or likely to essential for practical purposes. In the case of monitoring and collecting of traffic data rules 2009, this period is 9 months from the data of creation of record. Additionally, complete records relating to the order for the interception and monitoring are to be allowed by the intermediary during the time of duration of 2 months immediately after the discontinuance of interception or monitoring. If they are needed for every continuing investigation or court trial with reference to the monitoring rules, duration provided is 6 months since the date of discontinuance. Punishment is provided to intermediaries and subscribers for refusing to comply with the order for interception. Section 69 specifies a punishment of imprisonment up to term of 7 years and fine for any subscriber or intermediary or any person who fails to assist the agency authorized to intercept. Now, we will be moving towards the next chapter, that is online censorship and online surveillance. A department of the Ministry of Communication of Information and Technology that serves as a nodal agency for accepting reviewing requests from designated pool of governmental officials to block access to specific website. This chapter will provide an overview of how takedown requests in presence and absence of judicial officers are issued on regular basis. This discussion further states that companies occasionally facilitate governmental censorship by acting in accordance with governmental request along with filtering and blocking policies. These processes are varying and often infringe upon the freedom of expression in India. With so many procedures being used to confine online speech, there is an active deliberation in India about the effects of censorship on fundamental freedoms and society. The words such as an obscenity and incitement are not defined, owing to the ambiguity of the legislation, firstly, and secondly, the obligations of the legislations as to the interception of this term is subjective. The imposition of legislation has headed to the people being under arrest and accused for offensive posts and tweets. The Information Technology and Information Technology Amendment Act have not provided a distinct definition of the term offensive, and there is no regular public view of the concept of online and offline amount to vagueness, which has caused in rising propensity to report information considered offensive and request its elimination. Intermediaries, web business corporations that host information, however, do not create the content, and there is little incentive for intermediary to resist complying with the takedown of notices out of concern of being held accountable of the offensive content and then put on a trial. The excess over compliance of internet intermediaries with takedown notices is concerning as it eliminates legitimate speech from the internet. Solving this is difficult in absence of an appeal procedure. Intermediaries in India are not required to inform people if their posts or photos are removed, nor give individuals a chance to appeal the removal. Next sub-point for the further discussion is takedown request, and further point of discussion is provided under the image 1, which describes intermediary liability. Please have a look for the purpose of better understanding over image 1. Now the next chapter for the purpose of discussion is criminalization versus decriminalization of online speech. In 2011, Google, Facebook and Yahoo were asked to design a mechanism that would pre-filter inflammatory and religiously offensive content. This request was not only technologically difficult, but it was also strong attack on free speech. Also, the criminalization of online speech in India became a matter of great worry as numerous government establishments took legal action against dogmatic statements made online and individual opinions communicated on social media. Different speech openings available on social networking media in India have been objected after the passing of provision 66A of the IT Act, and arrest of number of Indian citizens for placing offensive information have been done. This chapter looks at in what way section 66A was violative of the right of freedom of speech and expression. Section 66A of the IT Act was being both overly broad and was defining disappropriate penalty. This section was added to the IT Act 2000 by amendment in 2008 with the view to penalize the communication of information which is grossly offensive or has menacing character, or any information which can cause annoyance, inconvenience, obstruction, insult, enmity, hatred or ill will among the other potential grievances. The provision carried a penalty up to 3 years imprisonment and a fine. Please have a look over the provision of Information Technology Act provided below. Much of the 2008 amendment to the IT Act has its origin from the 1935 UK Post Office Amendment Act, which is linked to phone calls and telecommunication messages. Instead of amending the legislation to eliminate these provisions as they were not framed to address digital communications, the Indian government adopted them into the Act. With this specific regard, there had been number of arrests done under section 66A of political condemnation on Facebook, Twitter and even via private email. This was disturbing development that demonstrate clamp down on political speech, including speech that may have a public interest purpose which should have been safeguarded. Criminal and civil cases registered against many of the internet companies for weakening to take out information considered by several people to be defamatory or religiously belligerent. This amount of censorship was uncalled for in an operative democracy. We will be discussing this thing in the next case study which we are going to discuss, that is Facebook post and apprehensions. For the purpose of better understanding, please have a look over the post mentioned by Shaheen Danda on Facebook with respect to the Shiv Sena chief Bal Thackeray and the post tweeted by Ravi Srinivasan with respect to the son of former finance minister Mr. P. Chidambaram. This prevalent disgust against the misuse of section 66A caused the Ministry of Information and Communication Technology to issue a guidance to states on how to implement the controversial section of IT Act. But there were continuing questions linked to political intrusion in the execution of law to the indefinite phraseology of the legislation itself, with the use of the overly broad terms such as annoyance, inconvenience, by giving organizations a comprehensive scope to criminalize comment and opinion. Beyond the guiding principles issued in 2012 to stop the exploitation of section 66A, an amendment in the legislation itself was required to avoid warrantless apprehension of under trials. In 2002, there was another case happened with respect to Asim Trivedi also. In January 2003, Rajiv Chandrasekhar, member of the upper house of the Indian Parliament, filed a petition to the Indian Supreme Court challenging section 66A and the Information Technology Intermediary Guideline rules for being arbitrary and uncanalized and in violation of the right available to citizens under Article 14, 19 and 21 of Constitution. In all 10 cases came up before the Supreme Court of India challenging various provisions of the Information Technology Act, the rules made thereunder and the other laws that got heard jointly in the case of Shreya Singhal versus Union of India. The judgment delivered on 24th of March 2015. Kindly refer table below for the better understanding of all three cases which have got disposed of on different points. While delivering the judgment, in conclusion, it was held by the Honorable Court that section 66A of IT Act is struck down in its entirety, being violative of Article 19(1)A and not saved Article 19(2). Section 69 and Information Technology Procedure and Safeguards for blocking for access of information by Public Rules 2009 are constitutionally valid. Section 79 is valid subject to section 79(3) being read down to mean that an intermediary upon receiving actual knowledge from a court order or on being notified by the appropriate government or its agency that unlawful acts relatable to the Article 19(2) are going to be committed, then fails to expeditiously remove or disable access to such material. Similarly, the Information Technology Intermediary Guideline Rules 2011 are valid subject to Rule 3 Sub-Rule 4 being read down in the same manner as indicated in the judgment. Section 118D of Kerala Police Act is struck down being violative of Article 19(1)A and not served by Article 19(2). All the writ petitions are disposed of in the above terms. Next discussion is about the status of unique identification number and Aadhaar card in India. For the purpose of better understanding, please have a look over the case which is discussed below in the chart. Unlawful Identification Authority of India and another versus Central Bureau of Investigation. The case is divided under the fact, issues and held. In March 2014, the Supreme Court of India ordered an ad interim relief in Unique Identification Authority of India and another versus Central Bureau of Investigation. Please have a look over the case analysis given below for the purpose of better understanding. The case analysis is done under the two different headings, that is fact and held and the appraisal of the case. After the discussion regarding the UIDAI case, we are heading towards concluding today's discussion. For the better understanding, conclusion is divided into three parts, that is an analysis, then findings, and then recommendations. While analyzing this topic, this is the time for Indian government should take into the consideration the right to privacy and safeguard from arbitrary intrusion with one's privacy, speaking about major surveillance and unjustified digital interceptions in India are both essential stages to combat self-censorship and to endorse freedom of speech and expression. Being great, the emerging nation, India has to create strong guidelines and procedure in order to defend IT industry as well as to guard privacy of all citizens, considering above discussed facets of cyber surveillance. For the purpose of analysis, kindly have over the 3 points mentioned in the chart below. Now, with respect to the findings, for the purpose of better understanding with respect to the findings, please have a look over the image 2 provided below, whereby the concerns have been divided into the 3 parts, that is judicial concern, investigative concern, and then the legislative concern. Then coming to the recommendations, have been summarized to resolve the concerns as mentioned in the analysis and finding which we have discussed earlier. For the purpose of better understanding with respect to the recommendations, please have a look over the image 3 provided below. And at the end of the discussion, I would say thanks for listening patiently. Thank you very much.